Chapter 2 Proof of Filiation of Legitimate Children Article 265. The filiation of legitimate children is proved by the record of birth appearing in the civil register, or by an authentic document or a final judgment. 115. Article 266. In the absence of the titles indicated in the preceding article, the filiation shall be proved by the continuous possession of status of a legitimate child. 116. Article 267. In the absence of a record of birth, authentic document, final judgment, or possession of status, legitimate filiation may be proved by any other means allowed by the rules of court and special laws. 117a. Article 268. The action to claim his legitimacy may be brought by the child during all his lifetime, and shall be transmitted to his heirs if he should die during his minority or in a state of insanity. In these cases the heirs shall have a period of 5 years within which to institute the action. The action already commenced by the child is transmitted upon his death to the heirs, if the proceeding has not yet lapsed. 118. Chapter 3 Legitimate Children Article 269. Only natural children can be legitimate. Children born outside wedlock of parents who, at the time of the conception of the former, were not disqualified by any impediment to marry each other, are natural. 119a. Article 270. Legitimation shall take place by the subsequent marriage between the parents. 120a. Article 271. Only natural children who have been recognized by the parents before or after the celebration of the marriage, or have been declared natural children by final judgment, may be considered legitimate by subsequent marriage. If a natural child is recognized or judicially declared as natural, such recognition or declaration shall extend to his or her brothers or sisters of the full blood, provided that the consent of the latter shall be implied if they do not impugn the recognition within 4 years from the time of such recognition, or in case they are minors, within 4 years following the attainment of majority. 121a. Article 272. Children who are legitimate by subsequent marriage shall enjoy the same rights as legitimate children. 122. Article 273. Legitimation shall take effect from the time of the child's birth. 123a. Article 274. The legitimation of children who died before the celebration of the marriage shall benefit their descendants. 124. Article 275. Legitimation may be impugned by those who are prejudiced in their rights, when it takes place in favor of those who do not have the legal condition of natural children or when the requisites laid down in this chapter are not complied with. 128a. Chapter 4 Illegitimate Children Section 1 Recognition of Natural Children Article 276. A natural child may be recognized by the father and mother jointly, or by only one of them. 129. Article 277. In case the recognition is made by only one of the parents, it shall be presumed that the child is natural, if the parent recognizing it had legal capacity to contract marriage at the time of the conception. 130. Article 278. Recognition shall be made in the record of birth, a will, a statement before a court of record, or in any authentic writing. 131a. Article 279. A minor who may not contract marriage without parental consent cannot acknowledge a natural child, unless the parent or guardian approves the acknowledgement or unless the recognition is made in a will. N. Article 280. When the father or the mother makes the recognition separately, he or she shall not reveal the name of the person with whom he or she had the child, neither shall he or she state any circumstance whereby the other parent may be identified. 132a. Article 281. A child who is of age cannot be recognized without his consent. When the recognition of a minor does not take place in a record of birth or in a will, judicial approval shall be necessary. A minor can in any case impugn the recognition within 4 years following the attainment of his majority. 133a, Article 282. A recognized natural child has the right, 1. To bear the surname of the parent recognizing him, 2. To receive support from such parent, in conformity with Article 291, 3. To receive, in a proper case, the hereditary portion which is determined in this code. 134, Article 283. In any of the following cases, the father is obliged to recognize the child as his natural child, 1. In cases of rape, abduction, or seduction, when the period of the offense coincides more or less with that of the conception, 2. When the child is in continuous possession of status of a child of the alleged father by the direct acts of the latter or of his family, 3. When the child was conceived during the time when the mother cohabited with the supposed father, 4. When the child has in his favor any evidence or proof that the defendant is his father. N. Article 284. The mother is obliged to recognize her natural child, 1. In any of the cases referred to in the preceding article, as between the child and the mother, 2. When the birth and the identity of the child are clearly proved. 136a, Article 285. The action for the recognition of natural children may be brought only during the lifetime of the presumed parents, except in the following cases: 1. If the father or mother died during the minority of the child, in which case the latter may file the action before the expiration of 4 years from the attainment of his majority. 2. If after the death of the father or of the mother a document should appear of which nothing had been heard and in which either or both parents recognize the child. In this case, the action must be commenced within 4 years from the finding of the document. 137a, Article 286. The recognition made in favor of a child who does not possess all the conditions stated in Article 269, or in which the requirements of the law have not been fulfilled, may be impugned by those who are prejudiced by such recognition. 137. Section 2 Other illegitimate children. Article 287. Illegitimate children other than natural in accordance with Article 269 and other than natural children by legal fiction are entitled to support and such successional rights as are granted in this code. N. Article 288. Minor children mentioned in the preceding article are under the parental authority of the mother. N. Article 289. Investigation of the paternity or maternity of children mentioned in the 2 preceding articles is permitted under the circumstances specified in Articles 283 and 284. N. Title 9 Support. Article 290. Support is everything that is indispensable for sustenance, dwelling, clothing, and medical attendance, according to the social position of the family. Support also includes the education of the person entitled to be supported until he completes his education or training for some profession, trade, or vocation, even beyond the age of majority. 142a, Article 291. The following are obliged to support each other to the whole extent set forth in the preceding article: 1. The spouses, 2. Legitimate ascendants and descendants, 3. Parents and acknowledged natural children and the legitimate or illegitimate descendants of the latter, 4. Parents and natural children by legal fiction and the legitimate and illegitimate descendants of the latter, 5. Parents and illegitimate children who are not natural. Brothers and sisters owe their legitimate and natural brothers and sisters, although they are only of the half-blood, the necessaries for life, when by a physical or mental defect, or any other cause not imputable to the recipients, the latter cannot secure their subsistence. This assistance includes, in a proper case, expenses necessary for elementary education and for professional or vocational training. 143a, Article 292. During the proceedings for legal separation, or for annulment of marriage, the spouses and children shall be supported from the conjugal partnership property. After the final judgment of legal separation, or of annulment of marriage, the obligation of mutual support between the spouses ceases. However, in case of legal separation, the court may order that the guilty spouse shall give support to the innocent one, the judgment specifying the terms of such order. N. Article 293. In an action for legal separation or annulment of marriage, attorney's fees and expenses for litigation shall be charged to the conjugal partnership property, unless the action fails. N. Article 294. The claim for support, when proper and two or more persons are obliged to give it, shall be made in the following order: 1. From the spouse, 2. From the descendants of the nearest degree, 3. From the ascendants, also of the nearest degree, 4. From the brothers and sisters. Among descendants and ascendants, the order in which they are called to the intestate succession of the person who has a right to claim support shall be observed. 144. Article 295. When the obligation to give support falls upon two or more persons, the payment of the same shall be divided between them in proportion to the resources of each. However, in case of urgent need and by special circumstances, the judge may order only one of them to furnish the support provisionally, without prejudice to his right to claim from the other obligers the share due from them. When two or more recipients at the same time claim support from one and the same person legally obliged to give it, and the latter should not have sufficient means to satisfy all, the order established in the preceding article shall be followed, unless the concurrent obliges should be the spouse and a child subject to parental authority, in which case the latter shall be preferred. 145. Article 296. The amount of support, in the cases referred to in the 5 numbers of Article 291, shall be in proportion to the resources or means of the giver and to the necessities of the recipient. 146a. Article 297. Support in the cases referred to in the preceding article shall be reduced or increased proportionately, according to the reduction or increase of the needs of the recipient and the resources of the person obliged to furnish the same. 147. Article 298. The obligation to give support shall be demandable from the time the person who has a right to receive the same needs it for maintenance, but it shall not be paid except from the date it is extrajudicially demanded. Payment shall be made monthly in advance, and when the recipient dies, his heirs shall not be obliged to return what he has received in advance. 148a. Article 299. The person obliged to give support may, at his option, fulfill his obligation either by paying the allowance fixed, or by receiving and maintaining in his house the person who has a right to receive support. The latter alternative cannot be availed of in case there is a moral or legal obstacle thereto. 149a. Article 300. The obligation to furnish support ceases upon the death of the obliger, even if he may be bound to give it in compliance with a final judgment. 150. Article 301. The right to receive support cannot be renounced, nor can it be transmitted to a third person. Neither can it be compensated with what the recipient owes the obliger. However, support in arrears may be compensated and renounced, and the right to demand the same may be transmitted by onerous or gratuitous title. 151. Article 302. Neither the right to receive legal support nor any money or property obtained as such support or any pension or gratuity from the government is subject to attachment or execution. N. Article 303. The obligation to give support shall also cease, 1. Upon the death of the recipient, 2. When the resources of the obliger have been reduced to the point where he cannot give the support without neglecting his own needs and those of his family, 3. When the recipient may engage in a trade, profession, or industry, or has obtained work, or has improved his fortune in such a way that he no longer needs the allowance for his subsistence, 4. When the recipient, be he a forced heir or not, has committed some act which gives rise to disinheritance, 5. when the recipient is a descendant, brother, or sister of the obliger and the need for support is caused by his or her bad conduct or by the lack of application to work, so long as this cause subsists. 152a, Article 304. The foregoing provisions shall be applicable to other cases where, in virtue of this code or of any other law, by will, or by stipulation there is a right to receive support, save what is stipulated, ordered by the testator or provided by law for the special case. 153a, Title X Funerals, n. Article 305. The duty and the right to make arrangements for the funeral of a relative shall be in accordance with the order established for support, under Article 294. In case of descendants of the same degree, or of brothers and sisters, the oldest shall be preferred. In case of ascendants, the paternal shall have a better right. Article 306. Every funeral shall be in keeping with the social position of the deceased. Article 307. The funeral shall be in accordance with the expressed wishes of the deceased. In the absence of such expression, his religious beliefs or affiliation shall determine the funeral rites. In case of doubt, the form of the funeral shall be decided upon by the person obliged to make arrangements for the same, after consulting the other members of the family. Article 308. No human remains shall be retained, interred, disposed of or exhumed without the consent of the persons mentioned in Articles 294 and 305. Article 309. Any person who shows disrespect to the dead, or wrongfully interferes with a funeral shall be liable to the family of the deceased for damages, material and moral. Article 310. The construction of a tombstone or mausoleum shall be deemed a part of the funeral expenses, and shall be chargeable to the conjugal partnership property, if the deceased is one of the spouses. Title 11 Parental Authority Chapter 1 General Provisions Article 311. The father and mother jointly exercise parental authority over their legitimate children who are not emancipated. In case of disagreement, the father's decision shall prevail, unless there is a judicial order to the contrary. Children are obliged to obey their parents so long as they are under parental power, and to observe respect and reverence toward them always. Recognized natural and adopted children who are under the age of majority are under the parental authority of the father or mother recognizing or adopting them, and are under the same obligation stated in the preceding paragraph. Natural children by legal fiction are under the joint authority of the father and mother, as provided in the first paragraph of this article. 154a, Article 312. Grandparents shall be consulted by all members of the family on all important family questions. N. Article 313. Parental authority cannot be renounced or transferred, except in cases of guardianship or adoption approved by the courts, or emancipation by concession. The courts may, in cases specified by law, deprive parents of their authority. N. Article 314. A foundling shall be under the parental authority of the person or institution that has reared the same. N. Article 315. No descendant can be compelled, in a criminal case, to testify against his parents and ascendants. N. Chapter 2 Effect of parental authority upon the persons of the children Article 316. The father and the mother have, with respect to their unemancipated children, 1. The duty to support them, to have them in their company, educate and instruct them in keeping with their means, and to represent them in all actions which may redound to their benefit. 2. The power to correct them and to punish them moderately. 155, Article 317. The courts may appoint a guardian of the child's property, or a guardian ad litem when the best interest of the child so requires. N. Article 318. Upon cause being shown by the parents, the local mayor may aid them in the exercise of their authority over the child. If the child is to be kept in a children's home or similar institution for not more than 1 month, An order of the justice of the peace or municipal judge shall be necessary, after due hearing, where the child shall be heard. For his purpose, the court may appoint a guardian ad litem. 156a, Article 319. The father and the mother shall satisfy the support for the detained child, but they shall not have any intervention in the regime of the institution where the child is detained. They may lift the detention when they deem it opportune, with the approval of the court.